Hello and welcome to Analysis Law, and in this video we are going to see what is an anticipatory bail, what are the grounds, what are the conditions and what are the factors on the basis of which a person can be granted anticipatory bail and the relevant case laws related to the provision. Now, Section 438 of Cr.P.C deals with the concept of anticipatory bail, although it nowhere uses the term anticipatory bail, since this term was for the first time used by the Law Commission of India in its 71st report. The words which are used under Section 438 of Cr.P.C are the direction for grant of bail to person apprehending arrest. The basic meaning of anticipatory bail is that bail is sought in anticipation of arrest. That means where the arrest has not been made as yet, but in the event a person is being arrested, he shall be released on bail. So this is basically an immunity, and this is immunity which is not from the arrest but from the custody. That means this is not the fact that he cannot be arrested. The thing is, once he is being arrested, he can be released on bail if it is if the court on its discretion has decided to grant him this anticipatory bail. Then this immunity is provided to him that he shall not be detained further. Now, Section 438, subsection 1 of Cr.P.C deals with the grounds. So it says that where any person has a reasonable apprehension that he may be arrested for any kind of offense which is of serious nature, that means which is a non-bailable offense, then he can seek either the High Court or the Sessions Court. And while directing this person to be released on the anticipatory bail, the court would write in the order that in the event of such arrest, he shall be released on bail. So since this power in the hands of either the High Court or the Sessions Court is a discretionary power, and therefore the court has to be very cautious and has to take a prudent decision while releasing or while granting a person this anticipatory bail. The factors which have to be considered by the concerned courts while releasing this person on anticipatory bail are: the first thing is that the court would look into the accusation, the kind of accusation, what is the nature, what is the gravity of accusation. It should not be of that serious nature that he cannot be released on that basis. Then secondly, also has to see, the court also would see what are the antecedents of the applicant. That means he should not be previously convicted for similar offenses or for any offense which is of grave nature or serious nature. There should not be a possibility of the applicant to flee from justice. And fourthly, the court would also see what is the object of accusation, why this person applicant is saying that he has a reasonable apprehension that there can be a false accusation which can be made against him in respect of committing a non-bailable offense. Now, for instance, there can be a case where a politician is involved in some elections, and his enemy or his contender wants him to be removed from the field, and there might be a case where he might be indicted with charges of committing a non-bailable offense, so that he can be arrested during that time, that relevant time, and he should not be made available. So this is just one of the instances where the court is looking into the object. So object is maybe to humiliate him, to to injure his reputation, or anything of similar kind. Then Section 438 1A further says that in the event this person is being rejected with this anticipatory bail, then he shall be immediately arrested without warrant by the officer in charge of a police station. And at the time where the court has decided to grant anticipatory bail to such a person, then the court would also serve a 7 days advanced notice to the public prosecutor and the superintendent of police for giving them the reasonable opportunity to oppose the release of such person. It is also important that at the time of final hearing of this application, the applicant has to be present before the court. So it is mandatory unless there are other reasons in the interest of justice. Then what are the conditions which have to be imposed upon by the applicant during the release? So it says that he should make himself available for interrogation whenever it is required. He should not be involved either directly or indirectly in any promise or threat or inducement to dissuade any person who is acquainted with his case, or any witnesses in that case. And the third condition is that he should not leave India without the permission of the court. Apart from that, other conditions which can be imposed upon him are that he should be ready to furnish bail at the time when he's being granted anticipatory bail. So if such person is arrested without warrant, so therefore if he is ready to furnish bail, then if the magistrate who is taking cognizance of such offence, he decides that a warrant should be issued in the first instance, then in that case he shall issue a bailable warrant in conformity with the direction of court under section 438 subsection 1. We have that means seen that how a non-bailable offence can be converted into a bailable offence by granting him the privilege of anticipatory bail here. Then important case laws we can see here that in Guru-Bakht-Singh Sibia versus State of Punjab, it was actually clarified that what is this reason to believe when you are using this word. So it was clarified that reason to believe here means that he is likely to be arrested for committing a non-bailable offence. That means there has to be a belief that has to be based on reasonable grounds, and it should not be merely limited to any fear. Apart from that, it was also held that this should not be a blanket order. Blanket order means since the discretion is given to the courts, but again this discretion has to be judicial discretion, and it is only with respect to that charges, that accusations which are being made against him, in respect of which anticipatory bail has been granted. It is not that suppose a person has been charged with so many accusations under different provisions of different laws, and on that basis this is not a blanket order. It is not a uniform, it's not a overall that okay, he's being charged with 6 charges and he's released on anticipatory bail for all the charges. So that is not the case. That's why the term used here is no blanket order should be there. Then again it was said that anticipatory bail can't be considered as being limited by time. That means when the court is granting anticipatory bail to a person, the court is not giving any particular time period during which that person has to be released on anticipatory bail. There is no time frame, and this anticipatory bail may continue even till the end of the trial. So fifth point here is very important, that in public interest related cases where a person is involved in corruption, and this person is no other person but a person from the executive, or where a person is being charged with such accusations which is punishable with the death or life imprisonment, in those cases also no anticipatory bail can be granted. In Sushila Agarwal versus State of NCT, this is again a very recent and important case where the issue relating to time period was reinstated. What was stated in Guru-Bakht-Singh Sibia case also, but this was again in a better way. It was clarified in Sushila Agarwal case, and it was said that the protection of this privilege, this can't be limited to any time frame or fixed period, which I have already told you in the earlier. Then nothing in Cr.P.C is to indicate that this bail should be time bound. Again, it's saying the same things, and the court can again impose additional restrictions upon the person, and this is again clarified here, that it is not important that the person should be named in an FIR and only then he is seeking for anticipatory bail. The only word which is being used here is that he should have a reason to believe, or there has to be a reasonable apprehension. So even in cases where FIR has not been, there is no name mentioned in FIR regarding the applicant, even in those cases the person can apply for the anticipatory bail. But the important thing here is that this person should have the concrete facts. It should not be vague. And he should also mention the bare essential facts regarding the offense which for which the accusations are being made against him. Then there has to be consideration into the mind of the court that since it is such an order which actually hits the very liberty of the person, and therefore denial of bail amounts to deprivation of personal liberty of the person. Again, the same things which I have already discussed in earlier in the Cr.P.C case. Then who can cancel bail? It's saying that if the sessions court has issued or granted anticipatory bail, then either the sessions court or the high court can cancel the bail, anticipatory bail. But where it is being granted by the high court, then it is only the high court who can cancel the anticipatory bail. But again, anticipatory bail cannot be claimed by a person who is a proclaimed offender, and where a person has applied for successive applications, and once the application for anticipatory bail has been rejected, then he has to go for the regular bail and not the anticipatory bail. Why? Because once a person has been arrested, then obviously after arrest how can he be granted anticipatory bail? So it is just in the event that he is arrested, he should be released on bail. But once he is being detained, arrested and then detained, then he has to go for the regular bail. So I hope you understood this lecture here. In case you have any further doubts, you can ask me in the comment section. I will try to clarify all your doubts. Thank you for watching this video.